Good afternoon, everyone. Welcome to Turning 18 Legal Options, brought to you by Jana Morell and Christopher Tiffany of Raising Special Kids. My name is John McDermott, and I work for the Institute for Human Development in Flagstaff, Arizona. And we're happy to collaborate with Raising Special Kids to deliver this webinar via the Adobe web conferencing platform. So I'd like to share a couple of tidbits for housekeeping first. This is a listen-only webinar. Please utilize the chat area or the chat pod in your lower right for questions or comments. And we will be recording this webinar, and we'll have it archived in a couple of places that we'd hope to tell you about a little bit later. So I'm going to hand it over to Christopher and Jana. Thank you very much.
Great. Thank you, John, for that nice introduction, and welcome, everybody. Good afternoon. Welcome to this Lunch and Learn on Wednesday. I want to talk just very briefly about the mission of Raising Special Kids, and then we'll jump right into it. So our mission is to support and encourage families on the challenging journey of raising children with disabilities or special health care needs by providing parents with information, training, and support so that they can become effective advocates for their children in all systems of care. We recognize that turning 18 and raising children with disabilities that are over 18 presents a particular challenge for many families, and we hope that this information will be helpful and useful. My name is Christopher Tiffany.
Good morning. My name is Jana Morell. Welcome. Many parents do struggle with the gravity of the issues that arise when a child turns 18, and guardianship is just one of a number of options that may be appropriate. Families make their own determination as to what is right for them. This morning we're going to talk, or this afternoon, we're going to be talking about some of those options, starting from least restrictive to most restrictive.
And just a disclaimer, we are not lawyers, and we can't provide any legal advice. We highly encourage families to consult an attorney with any legal questions they may have, as federal and state laws are subject to change, and they do change. And John has the webinar companion up right there. If you would like to download those two items, the first one is a PDF of this presentation. The second one is the webinar companion that has a link to the Superior Court website where families can download information on guardianship particularly. These are the things that we're going to cover today. We're going to certainly talk about the age of majority. We're going to discuss decision making and being able to balance independence and protection. We're going to be talking about supported decision making and powers of attorney, guardianship, and then other considerations that families would want to think about when their child is reaching that age of majority. The age of majority is the age when minors cease to legally be considered children and assume control over their persons, actions, and decisions, thereby terminating the legal control and legal responsibilities of their parents or guardian over them and for them. Most countries set the age of majority at 18. And parents can petition courts no sooner than 6 months prior to the child's 18th birthday for guardianship.
Okay, as Chris mentioned earlier, one of our learning objectives was that decision-making topic, balancing independence and protection. Parents really do struggle with the gravity of this issue, the concerns about continuity of care throughout the lifespan of their child. Specifically, we're going to be talking about the decision-making process through a trajectory of least restrictive to most restrictive, starting with independent decision-making, which is an example of what most of our typical young people, how they enter into adulthood. That's independent decision-making, maybe ask a friend or a family member for advice. Supported decision-making, which is side-by-side. That's going to be when we're talking more specifically about powers of attorney. And then surrogate decision-making, which is the most supported process of decision-making made by another on the individual's behalf. So specifically right now, let's talk about supported decision-making. This allows young adults to retain the right to make decisions about how they live their lives, decisions about their living situations, their medical care, their work, and their social lives. Family members may be given authority to assist the young person with decision-making about issues like health care and finances, but the young person always makes the final decision. Under that topic of supported decision-making, a tool that families can utilize to help assist in that is powers of attorney. The different types that we'll talk a little bit about are durable general power of attorney, a durable health care power of attorney, and a mental health care power of attorney. This is a perfect example of that side-by-side support. The young person they still retain their right to make decisions as well, and they can retain the right to make their decisions, but yet can rescind the power of attorney at any point in time. So right now, I would like to highlight our webinar companion at this point. Within the webinar companion, there is a link to the legal options manual. And within the legal options manual, there are examples of these different types of powers of attorney that we're talking about. So now we're going to talk a little bit about durable general power of attorney. The durable general power of attorney allows a person to assist the young person with day-to-day financial matters. A person with a durable general power of attorney can sign financial documents on behalf of the young person and assist with banking activities. A person wishing to assist with the management of Social Security payments would also need to contact Social Security Administration to be established as the representative payee for the young person. This can also be done without a general power of attorney if the young person has the capacity to give informed consent. Durable healthcare power of attorney allows medical professionals to discuss medical care with a person other than the patient so that he or she can assist the young person with understanding and making these important decisions. This particular option is important for families to consider when we think about HIPAA laws. This restricts the physician's ability to discuss issues of health care with the parent if the individual is over 18. Under mental health care power of attorney, this specifies which decisions a representative may make on the young person's behalf in the event that he or she becomes unable to make his or her own decisions. Decision-making is primarily limited to 3 areas. Under records, the ability to receive and disclose medical information. For medication, consent to the administration of that medication. Structured treatment environment, which would be admittance to a treatment facility. The mental health care power of attorney provides the specific circumstances under which it may be revoked. And again, just to remind everyone, those documents are in examples of those documents are in the legal options manual. The link is in the webinar companion. Now, when we think about that trajectory of most restrictive decision making, an example of this is that surrogate decision making. This option is typically used when supported decision making is not possible or would not provide the protection that individual requires. And that would be guardianship, adult guardianship. Gaining guardianship is a legal process that involves petitioning the court and attending a hearing. In order for guardianship to be granted, the young person has to be found incapacitated, meaning that he or she does not have the capacity for providing informed consent. The inability to provide informed consent rules out less restrictive options like that power of attorney that we discussed earlier. While we're talking specifically about that most restrictive option, guardianship, that the guardian has the responsibility of everything: living arrangements, education, social activities, medical care. However, also taking into consideration what are the things in life that that the ward finds interesting. What are the things that help continue to make their life sweet? What are the things that help continue to help them grow as an individual? Those are the other additional responsibilities of guardianship. Now that we are talking, guardianship is about the person, conservatorship is about the money. While a guardian or a person with power of attorney can take care of day-to-day financial matters, a conservator makes decisions about the person's assets or estate. If the annual income is over $5,000, not including SSI, if there are financial assets that require management or property that requires management, the court may determine that a conservatorship is needed.
So let's talk about some of the other considerations that families need to know about. Special education transfer or delegation of rights, representative payee for Social Security, registering for Selective Service for our young men. We're going to talk a little bit about wills and special needs trusts as well. So getting into special education, when the child turns 18, in the eyes of law enforcement, IDEA, the Individuals with Disabilities Education Act, and everything really, that child becomes an adult and is responsible for making their own decisions when it comes to their IEP. And certainly their parents can still be involved in that process, but they don't have to be. This is a way that the child can delegate educational rights back to the parent to stay involved with their special education programming. So an adult student 18 to 22 who has a disability, who is not under guardianship, may consent to their parents or other person to act as the decision maker regarding their education by providing a transfer of rights paperwork. And you can find that also in the Legal Options Manual, example of what that looks like. Frozen. A representative payee can be a person or an organization who receives Social Security benefits on behalf of a beneficiary for the use in paying bills, giving the person spending money, or making payments in the best interest of the beneficiary. When you register for Social Security, you will need to set up a checking account with your name and your child's name to make Social Security deposits into a bank account. If you are the payee, the account needs to be set up to read mother or father for the child. If the ward or the child can handle their account, the account can read and. So depending on how this is set up, it'll either be addressed to the mother or father of, or both parties. And selective service, our military requires that all males that have reached the age of majority to register for selective services. You may be contacted in the event service is required, such as during a draft. You can register online or at the local post office. Fill out a little card with some check boxes, or you can go right online. And I believe that there is a section in registering for selective service where you can signify that the child has a disability.
Now we're going to talk just for a few minutes about wills and trust. In the case of guardianship, it is often useful to consult with a legal professional regarding wills and special needs trusts. There is no section, if guardianship is chosen, there is no section in the guardianship paperwork to designate a successor guardian. Guardianship, so you can transfer the guardianship via a living will through the will, so that would make it unnecessary for a successor guardian to petition the court for guardianship in the event that the guardian passes away. Once again, it's really important to note that if the family is interested in estate planning, to consult an attorney or speak with your local bank, there are lots of options for special needs accounts, and there are officers at the bank that can assist with that process as well.
So we went through the information really quickly. John, if you could pull up the webinar companion, actually open it up to show everybody. So we want to make sure that you all have an idea of what this looks like.
I'd like to note that on the webinar companion as well, there's the link to the Superior Court website includes a section called required training. If the family chooses to petition the court for full guardianship or limited guardianship, they are required to complete an online training course through the Superior Court website. That online training, after they've completed that, will allow them to print out a certificate that will be presented to the judge at the hearing. So we just wanted to also make note of that is included in there.
Yeah, and I'd like to turn your attention to the very first bullet point, the ADDPC Legal Options Manual, and that's where you can find sample forms of the powers of attorney, transfer of educational rights. If you look down, you can read more about special education transfer of rights from our Department of Education, put out some information. And as well, I wanted to highlight the Disability Benefits 101 link, which is a great website for showing folks that qualify for Social Security how they can still continue, how they can work and still receive benefits. So moving our young people with disabilities out of poverty by allowing them the opportunity to work.
And then another resource we would also like to highlight is Raising Special Kids offers a more detailed training for turning 18 legal options that participants can register to attend as well. And another support that is available is connecting with another parent. If a parent is interested in talking with another parent that's recently gone through the process of selecting guardianship, or perhaps just perhaps a side-by-side decision-making process through supported decision-making, they can contact our office, our Raising Special Kids office, and we can facilitate a parent-to-parent connection where they can talk with another parent that's recently just gone through that and be able to provide that support in that way.
We also would like to take this opportunity to answer any questions that we can. Certainly, we are not attorneys, but we can answer some questions. John, can you bring over the evaluation links as well? I want to talk about our drawing that we're going to have in the next couple of days for an iPad. If you complete the survey, you will be automatically entered to win an iPad that we will try to get to you before Christmas. So it'll be a nice little Christmas present. And if you have any questions, please feel free to type them in the chat box below, and we will be here. And again, for our family members or parents, please fill out the family survey, and for professionals, the professional survey. Well, thank you, Richard. We appreciate that. I see some more folks typing. Multiple attendees are typing.
Good.
Good deal.
We have time.
So we'll start with Lisa. My son will turn 18 next July. How soon do we need to start the process for the various powers of attorney?
You can do that. Hi, Lisa. You can do that at any point in time. It wouldn't be necessary until he turns 18. So if you choose power of attorney, you could do that on his 18th birthday. You could start that process that day. You could go ahead and begin now familiarizing yourself with the documentation. And like we said before, there are examples of those in the legal options manual, but absolutely, you can start that process the day he turns 18, because until then, you're still his guardian all the way up until his birthday.
About the guardianship.
If you choose guardianship, if you choose to go that route, you would not be able to begin that process until 6 months prior to his 18th birthday. And if his birthday's in July, that would be sometime in February perhaps, and you could petition the court by submitting your first packet in February.
Great. Jeanette, thank you for the thank you. Teresa, some children will require guardianship at the age of 18, but may reach a maturity of capability at a later age, maybe in their 20s. Guardianship can be revoked later. Can you address this process?
Yes, guardianship doesn't have to last forever, and it doesn't have to start at 18. If a family chooses to petition the court for guardianship when they're 25, because there's been successful supportive decision-making up until that time, and then the family finds that there are some barriers and there's needs for a guardianship to be in place, or if there's been an incident that's occurred that would cause that individual to become incapacitated later on, then certainly they could petition the court at that time. And like I said before, guardianship does not have to last forever either. So if there's been a rehabilitative process that happens after guardianship is obtained, then the family could petition the court to yes, and the ward even could petition the court to have the guardianship dissolved. Absolutely. Good question.
Great question, Teresa. Thank you. Okay, Paula. My son turns 18 February 3rd. He's mentally unstable at this point and most likely will be. Should I start the guardianship process papers right away?
You can start them now. Yes, if he turns 18 in February, yes, you could start that process now. Absolutely. And if you have any additional questions, and if you'd like to, chat separately, you can please feel free to call our office and we can talk more specifically.
Yvette, is there a link available that provides information pertaining to the cost of the different legal options?
Yes. Ooh, another good question. The Superior Court website has an outline of court costs and filing fees. All of those are listed very specifically on the Superior Court website. Powers of attorney, there is no charge unless there is a fee for the notary.
Right. Mm-hmm. And can you talk a little bit about the fee waiver?
Yes, you can. If you petition the court for guardianship, and there are court costs and filing fees involved in that process, there is a form called the Fee Waiver and Deferral Form. It's a separate document that's outside of the packets of adult guardianship. So whenever you're surfing the Superior Court website, you will see that those fee waiver and deferral packets are separate. And they're very, very specific because they have a packet of instructions and then a packet of forms. The fee waiver and deferral packet is required to be filled out prior to your hearing. So the day you go to court, you need to have those forms completely filled out and notarized. They are going to be asking you for information about the petitioner. So it's financial information about the petitioner.
That's the ward, right?
Not the ward, yes. So when you read it, you will see that. Whenever you petition the court, the judge will take a look at all of that and then make a determination of whether they will consider waiving a portion of those court costs and filing fees, and perhaps deferring till the determination has been made of whether or not the court or the ward is indeed incapacitated and indigent.
Excuse me. Okay, Patty, will I be able to listen to this webinar again? Will the link remain active so my husband can watch it too? We'll have Neil address that question.
So we won't have, the link won't remain active, so you can't just use the same link to access it. But within the next week or so, we should have the information available on our website. Generally, we'll put it right on the front page. There'll be a big rotator image you can click on that'll say turning 18, and you can click on it and then register and then go through the videos. And what I do is generally break them down into little like bite-sized chunks so that you can watch them a little bit at a time in case that works out a little bit better for you.
And if it's past the time we have it on a rotator, you can find it under our events and training on demand. All right, Jake, if I'm correct, waiver for court fees uses the child's income versus the income of the parents. Is this accurate?
Well, what will happen is whenever the petitioner walks into court, the court is looking at the income for the petitioner first. And then if the determination has, that's why they're requesting that decision to be deferred, the court to consider deferring the decision to charge the fee or court costs until the determination has been made. At that point in time, if the judge does determine that the individual is indeed incapacitated, then it will revert to the ward's information. And then if we've walked into court that day saying that this person is indigent, then obviously then typically the court costs and filing fees there would be a portion of it that would be chosen to be waived.
An indigent would be a child basically with no substantial income other than maybe a Social Security check, correct?
Absolutely.
Right.
Not have the ability to gain or to get or keep competitive employment.
Correct.
Does that help to answer your question there, John?
Jake,
sorry about that.
Okay, well, I don't see anyone typing. Maybe we should give folks just a few more seconds to type in if they have questions. Please don't forget to fill out the evaluation and be entered to win an iPad. We will also feature the winner in our Monday memo, hopefully with a picture. John, I don't know if you can bring those evaluation links up again. There we go. Thank you, John. Looks like we have another question typing. Okay, how can we help parents make a decision if they're not sure about what kind of guardianship to pursue? It's such a big decision.
Mm-hmm. I think by giving them all the information and all the options there are that are available to them so that they have enough information to make a decision that best meets their needs. They can absolutely talk with their child first and foremost, and then also they can talk with another parent. That can be helpful, but most importantly would be giving them all the information about the different options that are available so that they feel confident in their decision. The other piece of this that I think is important to note is that this is a fluid decision, that this is something that it may be a point in time where there aren't very many changes that need to be made. However, at some point in time in the next several years, the family may decide, yes, we do need to do something a little more formal. And then The other piece of it is perhaps there is just a short season of time that the family needs to have guardianship, and then the child continues to mature and grow and develop in their skills and their independent living, and they're feeling more confident and competent in their individual living situation, and then there is no longer a need for guardianship, or we want to step those supports down. So it is a very fluid thing. Guardianship, that particular decision doesn't have to last forever.
Yeah, I'm making sure that families are really informed of what the options are and what each of them really mean and how they would affect not only the child but the family as well. I think you're absolutely right. It's a big decision, and hopefully we can help inform the families with what their options are so they can make it. Thank you, Teresa. You have great questions today. Okay, well, thank you all so much for joining us on this Wednesday Lunch and Learn. Please don't forget to fill out the evaluation. I know I'm beating you guys over the head with that. But please look forward to more webinars to come in the new 2015 year.
Absolutely. Thank you.
Thank you, everyone.
Happy holidays.